Welcome to Crash Course Injury Law with Joe Ghabour.
Welcome back to Crash Course Injury Law with Joe Ghabour, founder of Joseph M. Ghabour and Associates. Joe is a personal injury attorney licensed in New Jersey, New York, and Florida. He gives injured people clear, practical guidance on their rights, insurance issues, and the decisions that shape a case. I'm Lisa Mosby, and today we're talking about how fault affects your case and how that connects to the choice between settling or filing a lawsuit. Welcome, Joe.
Hi, Lisa. Nice to be with you.
Joe, can you explain how New Jersey's comparative negligence rule works for someone who's never heard of it before?
Sure. In New Jersey, fault can be shared between people after an accident. So you can still recover money as long as you are not more than 50% at fault. If you're 51% or more at fault, then you can't recover against the other person. So basically, in a nutshell, as long as your level of fault is 50% or less, you can proceed with a lawsuit. However, your recovery is going to be reduced by the percentage of fault that is attributable to you. So, for example, let's assume that the case is worth $100,000 and you have 20% fault attributable to you, you will get $80,000. Very simple.
What are some examples of situations where a person might assume they can't pursue a claim, but the law still allows them to?
Well, the first thing is don't ever assume that you can pursue a claim without seeking legal consult with a personal injury attorney. You may be able to pursue a claim even if you, for example, were not wearing your seatbelt, you were distracted momentarily, you were speeding slightly, you slipped and tripped, or you didn't see a defect in a sidewalk and you fell on it. Don't assume just because some mistake may be attributable to you that you can't pursue a lawsuit in New Jersey.
And Joe, what kinds of facts or circumstances tend to reduce someone's ability to move forward because of comparative negligence?
Well, some things are non-recoverable. So, for example, if you are driving while intoxicated, even if the other driver is at fault, you are not going to be able to pursue a claim. Certain things are really, really severe when it comes to your ability to pursue a suit against the other driver. If you're driving recklessly, if you don't have insurance on your vehicle, um, those are things that are a bar to you being able to pursue a suit against the other driver. However, like I indicated earlier, there are some things which are, forgivable or basically will attribute some level of negligence to you, but will still allow you to pursue, such as failing to wear a seatbelt or, speeding slightly or not watching where you were walking as you fell. So things of that nature are okay. Serious things, like I just indicated, reckless driving, driving while intoxicated, those are a bar. You cannot sue as a result of, even if the other person's at fault.
And I'm sure there's always investigation or discovery, but once fault is made clear or clearer, how does that information influence early settlement discussions with the insurance companies?
Well, in any case, there's two things that we have to prove as attorneys. We have to prove one, who's at fault, and the other one is damages. You don't get to damages unless you're able to establish fault or at least a percentage of fault that is less than the defendant. So if liability is established early on, there is more of a likelihood that the insurance company is going to want to settle or is going to make a reasonable offer of settlement. If there is any dispute as to liability, the chances of them making any offer is slim to none. And even if they do make an offer, that offer is going to be very, very low. So long as liability is in dispute, do not really count on being able to settle the case. That's why it's always good to consult with a personal injury attorney to figure out the best course of action in proving that you are less liable in the accident than the other driver or the other person.
And then, based on your experience, what are some indications that a case might be resolved through settlement rather than going straight to a lawsuit?
Well, So most cases will settle. Sometimes you will have to file the lawsuit to get the case to settle, but generally, cases that settle pre-suit are cases where fault is clear. There is substantial injuries and medical treatment, and they accept responsibility. The insurance company for the defendant accepts responsibility. And so long as both sides are acting and communicating in good faith, there's a good chance that the case will settle. Again, if it doesn't settle, if they don't negotiate in good faith, then we have to obviously file the lawsuit and proceed with litigation. And when I say good faith, I just need to be clear about this. The defendant's insurance company does not have any obligation to treat the person who's injured with good faith. They don't have to act in good faith. They do whatever is best to save their shareholders money. So the less amount of money they can pay on a claim, they will do so. So always understand, and we've talked about this in other podcasts, where when the insurance company for the defendant calls you, you are not under any obligation to speak with him or her, the adjuster on the file, because anything you say will be used against you later on.
So, what usually makes a case shift toward filing suit instead of continuing settlement talks?
Well, lowball offers or no offers at all by the insurance company. When there are injuries and liability is clear and the defendant's insurance company is playing games, for lack of a better term, then there's no other option but to file the lawsuit in court and proceed with discovery and taking it to trial if necessary.
And I know it's rare, but I still want to follow this path because I think it's unfamiliar to many of us. Once a lawsuit is filed, what should someone expect from the process, especially in terms of timing and the steps that are involved?
Well, once the lawsuit is filed, we have to serve it on the defendant, and sometimes that becomes a problem in and of itself. Sometimes the defendant is nowhere to be found. The address on the police report is not the up-to-date address, or they just are never at the location where they're supposed to be for you to serve them. So that's usually the first issue. But once you get the service of process done on the defendant, then they have, in New Jersey, they have 35 days to answer the complaint. Sometimes that will be extended by consent, but they have 35 days to answer. Once the answer comes through and gets filed with court, we go through a period of discovery, which is basically a time where there's an exchange of information. The plaintiffs, we as the plaintiff's attorneys, we provide all of the medical records, we answer what's called interrogatories, we provide, all the documents that will support the plaintiff's position. Because remember, as the plaintiff, we have the burden of proof. The defendant doesn't have to do anything. It can still be successful in defense of his case or her case. But as the plaintiffs, we have the burden of proof. So once we do all the exchange of written information, there's usually a deposition, which is a question and answer session under oath, which has the same force and effect as if though the person being deposed is sitting in court. And once the depositions of the plaintiff and defendants are over, sometimes the matter will go to mediation. Sometimes the matter will go to non-binding arbitration. And if neither of those things resolve, sometimes the court will set up a settlement conference to try to settle the matter, with the judge being, the mediator, for lack of a better term. And if that doesn't work, then it gets scheduled for trial. In terms of timing, in New Jersey, there are different tracks for discovery, for the period of discovery. For automobile accidents, you're probably looking, or slip and fall for that matter, you're probably looking at about a year to a year and a half of discovery before we actually get scheduled for non-binding arbitration or trial.
So let's leave the audience with a little guidance here. For anyone unsure about fault or whether their case is at a settlement stage or a litigation stage, what's the best advice you can give them on getting clarity early on and taking the next steps?
The best advice I can give to anyone who is injured in an accident of any sort is consult with an attorney. Consult with a personal injury attorney. And the reason I say this is because there are so many facets to a case and there's so many things that the normal person would not know. So asking for advice from those who are experienced in this field is the best thing that you can do. It costs you nothing to consult with a personal injury attorney initially to see what your rights are, what your obligations are, at least to get an idea as to what your exposure is in terms of liability, what your exposure is in terms of medical costs in the event you're injured. And even under the no fault system of New Jersey, you still have a deductible and a copay that is based on your own insurance policy. So you have nothing to lose by consulting with an attorney, and you have everything to gain, to be honest with you.
Clarity comes with consulting with an attorney. Perfectly said. Thank you so much for your time today.
Thank you, Lisa.
My pleasure. Hey, folks, that's it for today's episode of Crash Course Injury Law with Joe Ghabour. To learn more about how fault, settlement, and lawsuits work in New Jersey injury cases, visit ghabourlaw.com. You'll find clear, practical resources on protecting your rights after an accident. Thanks for listening. And don't forget to subscribe, leave a review, and maybe share this episode with someone who might be in need of it today.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.